Good morning, ladies and gentlemen, and welcome to this Data Protection Act 2018 web seminar. My name is Ibrahim Hassan. I'm a solicitor and director of ACNOW Training. And for the next hour or so, we will be looking at the new Data Protection Act 2018. Came into force at the same time as GDPR, 25th of May of this year. The Data Protection Act 2018 has a number of purposes. But before we look at the purposes, let's just bust some myths. Many people think, and including a lot of so-called experts within the media, that the Data Protection Act 2018 implements or brings into force the General Data Protection Regulation. It doesn't. GDPR was always going to come into force on the 25th of May. GDPR is a regulation, a European regulation, which is directly enforceable. It does not need any UK or member states to implement it. What GDPR requires, though, is in a lot of areas, it requires member states to fill in the gaps. And this is what the Data Protection Act, amongst other things, does. In addition, the Data Protection Act addresses certain other areas that GDPR does not. But what DPA does not do is gives people new rights in relation to their data. Those rights are contained within GDPR. Okay, that is important to bear in mind. Of course, the Data Protection Act and the GDPR have to be read together to fully understand the UK's data protection regime. And it is correct to say that GDPR completely replaces the Data Protection Act 1998. That's now gone. Excuse me. So what does the Data Protection Act do then? Let's have a look at this in a little bit more detail. What does the Data Protection Act 2018 do? First of all, it fills in some of the gaps within GDPR. Within GDPR, there are what are known as derogations. Derogations. These are areas where member states, because remember GDPR applies across Europe, all the countries within the EU, those member states may sometimes wish to pass their own legislation filling in some of the gaps within GDPR. For example, GDPR is silent on exemptions. It tells you what member states can enact as exemptions, but doesn't actually give you those exemptions. For those exemptions, you have to look at, in the UK, the Data Protection Act 2018, in particular, Schedules 2 to 4. So whereas previously, if you want to know about data protection, you would read the 1998 Act, it would contain the general rules, and it would contain the exemptions. Now we have to read the GDPR for the general rules. For the exemptions, we have to read the Data Protection Act 2018. In addition, there are other gaps within GDPR. For example, member states are allowed to lower the age at which children can consent to the processing of their personal data for the purpose of information society services. And we'll look at the definition. So in that area, GDPR, once again, fills in the gaps by lowering the age. GDPR, in addition, gives you definitions of public authorities, imposes additional requirements if you are processing special category and criminal history data. It creates new offences, which you will not find within GDPR. You will find them within the Data Protection Act. So first and foremost, the Data Protection Act fills in some of the gaps within GDPR. The GDPR does not cover certain types of processing. The Data Protection Act adds that type of processing into GDPR. So for example, manual records are not covered by GDPR. If you have paper records containing personal information, if we only had the GDPR, then you would not have to do anything. Individuals would have no rights in relation to their unstructured personal records. Well, the Data Protection Act adds those records into the GDPR regime, and we'll have a look at that. You may be familiar with the Law Enforcement Directive. Hands up those of you who are from a local authority. Anyone else? Okay, Chris is from a local authority. So, Chris and Joe, you may know about this. The Law Enforcement Directive requires, okay, we have some more people as well from a local authority, so 4 of you. The Law Enforcement Directive was supposed to be implemented on the 5th of May of this year. It wasn't. It was implemented on the 25th of May via the Data Protection Act. Law Enforcement Directive imposes obligations on organizations that process information for law enforcement purposes. So that's now covered by the Data Protection Act because it was a directive it needed implementing. MI5, MI6 are not covered by GDPR, but they are covered under the Data Protection Act 2018. A sort of a cut down version of GDPR is included. And then finally, some of the powers of the Commissioner in terms of enforcement and duties, they are contained in more detail within the Data Protection Act 2018. So remember, amongst other things, the Act implements the Law Enforcement Directive, fills in some of the gaps within GDPR. So it has to be read together with the GDPR. Let's look at it in a bit more detail then. In terms of Commissioner powers and enforcement, most of the powers of the Information Commissioner are contained within GDPR itself, but there are some gaps. Those gaps have been filled in by clause 171 onwards of the Data Protection Act, as well as other provisions. The Information Commissioner has lots of powers, all set out within the regulation itself. Most importantly, she can fine organizations for failing to comply with the legislation. What's the maximum fine now under GDPR if you fail to comply? Does anybody know? Maximum fine for failure to comply with GDPR is, type your answer into the chat function. Do I take it? Nobody? Ah, yes. Let's see if you got the zeros correct. Yes, 20 million euros or 4% of gross annual turnover if you are a private company. So most of the powers of the Commissioner are contained within the regulation itself. But the Commissioner, under the 1998 Act, also had the power to prosecute individuals as well. She could prosecute individuals for various offences set out within Section 55 of the Data Protection Act. Those offences and other offences are now contained within Section 170, 171, and it should say 173 of GDPR, of the Data Protection Act. So, a couple of new offences first. Intentionally or recklessly re-identifying individuals from anonymized or pseudonymized information, or knowingly handling such personal data. This is now a criminal offence under the Data Protection Act 2018. So that is Section 171. Okay, so you might just want to change that. That is Section 171. Section 172. Sorry, Section 173 is altering, destroying records with an intention to prevent a disclosure following a rights request. So basically what that means is that if a person makes a subject access request, for example, you cannot amend, destroy, or alter those records with a view to frustrating that request. That would be a criminal offense. That is section 173 of the Data Protection Act. So these are offences which were not within the Data Protection Act, and they're not within the GDPR either, but they are now contained within the 2018 Act. Intentionally or recklessly re-identifying individuals from anonymized or pseudonymized data and knowingly handling or processing such data. And secondly, altering or destroying records. So what you cannot say is, somebody made a subject access request to your organization, and you say, well, I was walking past a shredder and accidentally my hand slipped and I lost their records. That would be a criminal offense. At the moment, it's a fine within the magistrate's court, £5,000 in the magistrate's court, unlimited fine in the Crown Court, but the Commissioner has been lobbying for a while for criminal custodial sentences for these offences. Section 170 is the old Section 55 offence, handling, disclosing, procuring a disclosure to another person, unlawfully selling personal data. But that offence has been widened, retaining data against the wishes of the data controller, even where the data was originally obtained. So you receive information from the data controller, you process that information, perhaps on behalf of the data controller, and then instead of giving it back to them, you keep it. Your contract, perhaps you are providing a service to another organization, another local authority, your contract says it must be returned, you keep it, then you are committing a criminal offense. So 2 new offenses set out within the Data Protection Act 2018 supplement the enforcement provisions within GDPR. Remember, you can ask a question at any time. If you want, you can ask me to unmute your line so you can speak to me directly. Alternatively, you can just type your question into the chat function. Okay, let us move on then. Remember, GDPR, just like Section 13 of the Data Protection Act 1998, contains provisions whereby individuals and organizations can be sued within civil courts. As your organization can also be vicariously liable for the actions of your employees. So even though you're not directly at fault, if an employee does something with personal information, you could still be held liable unless you have taken reasonable care. Article 82 of GDPR changes the sort of game slightly, in that it says that any individual or organization can be sued in the civil courts for compensation. Now, previously, compensation meant material damage. If an organization had lost your personal information or had it stolen and you directly suffered as a result, it could be because your identity was defrauded. It could be because money was taken from your bank account. That is material damage. You could sue. But for distress alone, just being distressed, just being upset at the fact that your data has been lost or stolen, you could not sue. GDPR allows compensation for non-material damage. That includes distress according to Section 169 of the Data Protection Act. So the Data Protection Act makes it very clear now, under the 2018 Data Protection Act, that non-material damage includes distress. Okay, let's have a look at some more. That is Commissioner and enforcement, some of the supplementary provisions within the Data Protection Act 2018, which fills in some of the GDPR gaps. Any questions, anyone, before we move on? If you want me, you can ask me to unmute your line and we can have a discussion. Alternatively, you can type your question into the chat function. Lucy, you've got a question. Is there likely to be guidance on payouts for compensation under distress? Yes, that guidance will come from the European Data Protection Advisory Board in terms of what you should be doing to avoid the actual sort of avoid the breach happening in the first place, or who can sue. But bear in mind, in terms of the actual compensation, Lucy, that is something for the courts to decide. And I don't think it's not been legislated on, as in the amount of compensation. Remember, the legislation only applies to fines. That's direct action by the commissioner, but anybody can take action within the courts for compensation, and then that is really a matter for the courts to decide. So I don't think there'll be much guidance on that, but there will be guidance in terms of who can sue and what sort of standing they have in terms of before the courts. Okay, hopefully that answers your question. The place to look for is the European Data Protection Advisory Board, which took over from the Article 29 Working Party. If you Google Article 29 Working Party, you will end up with the European Data Protection Board. Okay, let's go on then. Let's look at more gaps within GDPR filled in by the Data Protection Act 2018. We know the definition of personal data. It is set out within Article 4. You can summarize it by saying, well, the same things as under the old 1998 Act. Personal data is information about living identifiable individuals. Okay, Article 4 goes into more detail, but doesn't really add to the definition. This includes, well, GDPR says, personal data is only personal data if it's processed by automated means, basically on computer, mobile, or other devices. Alternatively, paper records containing personal data, but only if those paper records contain personal data and those paper records are part of a relevant filing system, i.e. a structured filing system structured by reference to the individual or criteria relating to the individuals. So you have a set of manual medical records. If you're in the NHS, they're not on computer, they're on paper, and those records are in files, and the files, at the top of the file is an individual's surname, and they're filed by reference to surname. That is a relevant filing system, a structured system. Those paper records are covered by GDPR. However, if you are not a public authority and you have personal records on paper, and those personal records are all over the place, there is no structure to them, they're not part of a filing system, you would have to wade through all the records in order to find some personal information about a single person. That would be an unstructured paper record system that is not covered by the GDPR regime. Unstructured paper records are not covered unless you are a public authority. A public authority, i.e. an organization covered by the Freedom of Information Act or the Freedom of Information Scotland Act, in which case the Data Protection Act 2018 adds unstructured paper records to the definition of personal data. But that's only in relation to public authorities. If you are a private company, then unstructured personal records are not covered. Hands up if you're from a private company. Anyone? Anyone from a private organization? Okay, looks like you're all from the public sector, in which case remember your unstructured pieces of paper lying about with personal data on them, they are also covered by GDPR. But if you read the legislation, you will find that some of the aspects, many of the aspects of GDPR are not, do not apply to those unstructured records. In particular, you want to have a look at section 22, subsection 2, which tells you which provisions do not apply. Okay, so for example, the provisions relating to lawfulness, conditions for consent, data portability, etc., do not apply. In the main, an individual has a right to see the data. That's in relation to unstructured paper records. How does the Data Protection Act have an impact on the GDPR principles, the data protection principles? You know there are 6 of them, and they are contained within Article 5 of GDPR. First of all, personal data must be processed lawfully by reference to the conditions within Article 6. So you've got to have a good reason for processing personal data, just like you did under the 1998 Act. The Data Protection Act has something to add to consent. Okay, before we look at consent, what the GDPR says is that public authorities, and since you're all public authorities, you need to know this, cannot rely on legitimate interests where they are performing their public tasks. So where public authorities are performing a public task, council tax, housing benefit, health sector, etc., then you can only rely on one of the other 5 conditions. You cannot rely on legitimate interests. The Data Protection Act makes this very clear that that's only in relation to the performance of your public task. Other areas, for example, if you're a university, you need to raise funds, you need to raise money. It's not part of your public functions as such. You're engaging in activity involving personal data. Well, there you can rely on legitimate interests. Okay, so the bar to legitimate interests being used for the purposes of public authorities only applies to those public authorities when they are processing personal data in accordance with their public tasks. That's important to bear in mind. What else does the Data Protection Act say? In terms of consent, it doesn't add much, except where you are processing information in accordance with which relates to a child. You're processing information about a child, and that Article 8 says member states can include additional conditions applicable to a child's consent in relation to information society services. In addition, they can lower the age for the purposes provided to not below 13. So what this means, Section 9 of the Data Protection Act 2018 lowers the age at which children can consent to their personal data being processed for the purpose of information society services. What does that mean? If you're offering goods or services to children online, and you're relying on their consent to process their personal information, then in that situation, if the child is younger than 13, then you cannot rely on their consent. You have to seek the parents' consent. So if they are less, their age is lower than 13, you have to rely on parental consent. You can't just ask the child for consent. But remember, that only relates to the offering of information society services, social networks, offering goods or services online, etc. It does not apply to normal processing of personal information. There, as long as you're satisfied the child has sufficient capacity to give their consent, and of course you follow the other rules about consent being freely given, specific, informed, relying on opt-in rather than opt-out, then you can ask and the child can give their consent to the processing of their personal data. Principle 1 also requires you, and this is supplemented by Article 9 as well, where you're processing special categories data, any data which falls into one of those categories, you previously known as sensitive personal data, then you can only do so if you're relying on one of the conditions within Article 9. Article 9 also allows member states to add additional conditions. Article 9.4 in particular allows member states to add additional conditions to make your processing of sensitive personal data to make it lawful. Data Protection Act, Section 10 and Schedule 1 adds additional conditions only where you're relying on certain specific provisions within Article 9. So if you are processing sensitive personal data, and as you will be for the purpose of employment, because you are all employers, for the purpose of public health, perhaps if you're a local authority, public health departments, health and social care, social services, you're processing sensitive or special categories data, you're relying on these conditions to make it lawful. In addition, you need a policy document. Section 10, Schedule 1, Part 4 requires you to have a policy document setting out, amongst other things, how you will comply with the principles, the rights, you will review it, you will make it available to the Commissioner, you will have to add an explanation of the conditions that you're relying on in your Article 30 record as well. So sensitive personal data, special categories data, if you're relying on one of these conditions to process it, and you will all be relying on employment law, you will have information about your employees, then you will need a policy document. Hands up if you have already, or should have, certainly, by now completed your policy document for the handling of special categories data. Has anybody done this? Raise your hand, please, or tell me via the chat function. Tell me who you are, your organization, so the rest of them will probably try and find you by Googling you and asking you for a copy, unless you give them your email address or give us. Anybody done this? Simon's done it. Simon's produced a policy document. Anybody else done it? Okay, I'll let you decide, Simon, whether you want to type your details in to let others know how they can contact you to get ideas about this policy document. That's a matter for you. I will not disclose your personal data, Simon. GDPR contains lots of general rules about lawfulness, about fairness, about transparency, about the other conditions about how long data should be held. It should not be processed for other purposes unless you have a good reason. But like the Data Protection Act 1998, GDPR contains exemptions as well. It contains the provisions for public, for data controllers, for member states actually, to produce their own list of exemptions. Article 23 explains, as well as Article 6.3. Article 23 gives you a set of exemptions that member states can enact. So the exemptions are not found within GDPR itself, they're found Section 15 of the Data Protection Act 2018, as well as Schedule 2, 3, and 4 of the Data Protection Act 2018. How are the exemptions explained? Well, you have the general rules. Each of the exemptions, which you will find Schedule, as I've said before, Schedule 2, 3, and 4, it will say this exemption applies to the following listed GDPR provisions. Those provisions are identified, i.e., what you do not have to comply with in GDPR because you're relying on this exemption. So you have to read the exemption very carefully. The exemptions, there are lots of them. They are very similar. If you know about the Data Protection Act 1998, Section 29 to 36, as well as Schedule 7, contain the exemptions. The exemptions within GDPR are very similar. The only problem you have is that you have to skip to Schedule 2 to 4 to find them. So there is an exemption for national security, for defense. Criminal investigations, you receive a request from the police, or you need to disclose information to the police or to other agencies for crime prevention. You have an exemption similar to Section 29. You need to take legal advice, legal proceedings. You are required by law to disclose information. All those exemptions can be found within Schedule 2 to 4 of the of the Data Protection Act 2018. You've got other exemptions for legal privilege, legal advice you have received or given as a lawyer. Confidential references are included, exam marks, exam scripts. So in the main, it is the same as under the previous Data Protection Act. However, a couple of exemptions that I would like to refer you to, 2 or 3 maybe. References. Schedule 2, paragraph 24 of the new Data Protection Act. Previously, a reference which you as an employer have given, confidential reference, an employee applies for a job in another organization, you as a manager are asked to give a reference, you send a reference to the prospective employer. The employee makes a subject access request to you, you can withhold the reference that you have given. However, they can still get hold of the reference from the receiving organization. So references that you have given as an employer are exempt or were exempt. References that you received were not exempt. Well, Schedule 2, paragraph 24 went through a change during the passage of the Data Protection Parliament, and now, as enacted, all references, confidential references, are exempt from the right of subject access. All confidential references, whether you have given them, whether you have received them, they are exempt from the right of access. But in addition, Schedule 2, paragraph 24 says that this exemption also applies to volunteering. Anybody applying for a volunteer position, any references that you receive or give about them, they are also exempt from mainly the right of access. So that's quite a fundamental change, which I don't think many people have picked up on. Part 6 of the GDPR, of the Data Protection Act, exempts personal data which is being used for research and statistical analysis from many of the provisions of the GDPR. You need to look at, I think it's Article 89 of GDPR as well, where certain safeguards have to be put in. Lots of other exemptions as well. Okay, there's one for health, education, social work, child abuse data. Gives you exemptions from lots of other provisions. Have a look at Schedule 3. Just looking at the time, I want to move on. GDPR does not contain or exempts actually personal data which is being used for, are being processed by law enforcement agencies for law enforcement purposes. Why? Because if you're handling such personal information for such purposes, then you are governed by the Law Enforcement Directive, which is now implemented by the Data Protection Act 2018. So that it was a directive, remember, it needed to be implemented. The Data Protection Act does this. I think it's part 3 of the Data Protection Act. What did the directive do? Tells you there. But remember, the directive only applies to competent authorities. So we'll come back to that because the Data Protection Act, Section 30 and Schedule 7 tells us who those competent authorities are. If you are a competent authority and you are processing personal data for the purpose of prevention, investigation, detection or prosecution of criminal offences, or the execution of criminal penalties, or safeguarding against and prevention of threats to public security, then in that situation, the personal data that you are processing is not governed by GDPR, it is governed by the Data Protection Act 2018. So here you do have a comprehensive regime when it comes to personal data, but that only relates to law enforcement purposes and implementing the Law Enforcement Directive. Okay, so that is important to bear in mind. Part 3 of the Data Protection Act 2018. Who are these competent authorities? Who has to comply with GDPR and probably in addition, Part 3 of the Data Protection Act? Well, look at Section 30 and Schedule 7. It gives you a list of organizations. It includes local authorities, trading standards departments, for example, your public health department, if they are in charge of also prosecuting individuals for environmental health offences, etc. The police are also covered, the Crown Prosecution Service, and various other organisations. So Section 30 and Schedule 7 refers. Local authorities, definitely your trading standards, environmental health departments, because they are involved in processing personal data for the purpose of law enforcement, criminal penalties, they will have to, in terms of some of their data, the normal run-of-the-mill information, they'll have to comply with GDPR. Other information, they will have to comply with Part 3 of the Data Protection Act. What does Part 3 of the Data Protection Act require you to do? I'll tell you about that. Remember, under Part 3 of the Data Protection Act, once again, failure to comply could lead to a fine of 20 million euros or 4% of gross annual turnover if you are a company. So the fines are the same as GDPR. Basically, Part 3 and the Law Enforcement Directive is a cut-down version of GDPR. So you still have the same principles, slightly watered down, the same rights. You have to notify the commissioner if you suffer a data breach, the rules on international transfers, appointing a data protection officer, doing a data protection impact assessment. We still have the same commissioner. So these are all very familiar concepts. If you know about them under GDPR, then you don't have to worry too much. It's not a very steep learning curve when it comes to Part 3 of the Data Protection Act, the Law Enforcement Directive. What are the differences then? There's a reduced transparency requirement. You don't have to go so far in terms of privacy notices, etc., when it comes to law enforcement information. The standards for consent, if you're relying on consent, are not as strict. Principle 4, there are additional requirements to comply. So there's a requirement to categorize data subjects, victims, witnesses, suspects, offenders. So you have to say, in relation to all your personal data processed for these purposes, what kind of person does it relate to? A victim, a witness, a suspect, or an offender in terms of criminal offences. And you also have to flag within the data the fact that whether it is fact or a personal assessment or an opinion of a law enforcement officer. And you also have to log requirements. You have logging requirements to record who accessed the information, when and how. So similar, but not the same as GDPR. Remember, this applies to law enforcement data. So not just the police, local authorities, various quangos will have the powers to prosecute individuals, Health and Safety Executive Charity Commission, etc., etc. Have a look on the Information Commissioner's website. She's produced a document for preparing for Part 3 of what was the bill before, 12 steps to take now, similar to the 12 steps under GDPR. So you should be raising awareness, mapping your information, considering lawful basis, appointing a data protection officer. You should ensure that you are able to keep logs of processing operations, as we just discussed. This will include a log of altering records, access to records, erasure and disclosure, etc. So that is Part 3 of the Data Protection Act 2018, implements the Law Enforcement Directive. Finally, Schedule 19 of the Data Protection Act 2018 amends the Freedom of Information Act in the UK, as in England, we have the 2000 Act, in Scotland, with England, Wales, and Northern Ireland, and in Scotland, we have the Scottish Act 2002. They contain references to the Data Protection Act. If you are processing personal data, it is exempt from the right of access under FOI, under Section 14 or Regulation 13, where you feel that disclosure would breach one of the data protection principles. Schedule 19 amends those exemptions to refer to GDPR as opposed to Data Protection Act. This amendment will not affect the way you apply the personal data exemption, either under FOI or under the Environmental Information Regulations. In addition, one final point to bear in mind is GDPR defines public authority as an authority which is covered by the Freedom of Information Act or the Freedom of Information Scotland Act. However, the Data Protection Act does exclude from that definition various organisations, including parish councils. And that is important because if you advise parish councils, the requirement to appoint a data protection officer, it says that one of the requirements is where you are a public authority. Parish council is not a public authority for GDPR purposes. It still is under FOI, but not under GDPR. That means that it does not have to appoint a data protection officer, unless, of course, it's processing special categories data or one of the other conditions applies doing surveillance of a publicly accessible area on a large scale. So those are the FOI sort of changes, you could say. Okay, any questions, folks? That's what I propose I have covered. I think I've been through sort of the main sort of changes and the main additions that the new Act makes to the GDPR. But of course, this is your course. So any questions before we move on to do the test? Type your question into the chat function. Alternatively, you can ask me to unmute your line so you can speak to me directly. Remember, this works if you've got a microphone attached to your computer. Anyone want to typing in a question? Or anybody got a question? Raise your hand. Okay, let us move on. Before we do the test, let me tell you about our website, actnow.org.uk. Lots of other articles and resources, lots of courses. I am doing a course in Leeds, and we've got a course in London as well on the Data Protection Act 2018, which goes into much more detail, a full-day course. Have a look at actnow.org.uk. We have a question, folks. Good question, Chris. Do we have to mention both the GDPR and the DPA 2018 when referencing data protection legislation, or can we just use DPA? You can just say current data protection legislation, Chris, if you don't want to use the full term, although technically it's the GDPR as well as the Data Protection Act 2018, or supplemented by the Data Protection Act 2018, you could say. Both pieces of legislation technically should be mentioned, but as I say, if you use the catch-all term current data protection legislation, I think that would be okay. It depends on the context in which you need to reference the legislation. If you're relying on an exemption, for example, somebody makes a subject access request, you're relying on an exemption, I think there you have to mention both legislation because the exemption is contained within the Act. Is that okay, Chris? Okay. Before we do the test, So have a look at our website, actnow.org.uk. In addition, if you are advising in this area, you are somebody who's the data protection officer perhaps, well, have a look at our website. We have the Data Protection Practitioner Certificate, our most popular course by far. This leads to a qualification, and it covers all the major aspects of the Act as well as the GDPR. We cover PECA and marketing, and very useful if you are a data protection officer or an advisor. It's a 4-day course, 1 day per week, followed by an exam, although in the summer in Manchester and London, we have an intensive course, which is 4 days in a row. After you've done the 4 days, you have to do an online exam, and then in addition, within a month, you've got to do an open book project. Extremely popular. Have a look at the website for more details. In addition, for those of you who need to train frontline staff, they don't need a full day training course. We've got an e-learning package, which is currently very popular as well. Finally, if you've got any other questions or queries, you can always get in touch. Okay, we will now do the test. Question: are there any provisions that allow exemptions where for MSAMs, I'm not quite sure, were explicitly mentioned in other legislation, e.g. with regards to electoral registers? Yes, there is an exemption, Simon, for where you are required by law to withhold information, secrecy provisions, etc. And whilst you do the test, Simon, I will look for that particular exemption. Okay, we'll end the recording here, and the rest of you will do the test.